this. Let's get this party started. I don't think of, popping tops and dancing and all that stuff. I actually think of political party. And I know that sounds dumb, but see, I know that the birth record, and this is off topic for the night, but the birth record, and I can prove this, by the way. In fact, I'm going to go ahead and upload these documents tomorrow. The birth record identifies your willful participation in communism. So by not doing what's correct with that birth record, a communist position, which be undermining or ultimately a traitor to the United States of America. So the whole idea is that in like 1925, a case came out about a guy handing out tracts that basically were either progressive or communistic, but in nature. And it's funny that the case came out in like 1925, just a few years before the birth record came out, which also evidences a communist position because the Roman Catholic Church is pure communism. But anyway, let's get back to tonight. It's about claims. Whose is it and who can prove it? Ultimately, that's everything. And again, I've been trying to explain to people that even biblically, the concept of commerce, the whole idea of commerce, the idea of the flood. The flood is not about water. It's about the sea of commerce. And Hammurabi, way back when, it's been about commerce. So when commerce, the world, the sea of commerce flooded the earth, that's what it was all about. It was about that flood. By the way, the earth is still flooded. And what you need, obviously, to survive such a flood is a boat. So anyway, it is all about claiming, and basically it's going to come down to a vessel. But let me just look at my notes real quick, because I think that on the list of potential references, I put a book out there called Who's Monet by John Humbach, and it says an introduction to the American legal system. And what's interesting about Who's Monet is I think I'm going to go ahead and just read what the book is about. I'm not going to read the book, obviously, because I read too slow. But I'm going to read what the book is about, because my topic tonight is going to be about my son, my child. And it all is going to connect. You'll see how it connects in a bit. So I'm going to go ahead and read the DeWerth versus Baldinger case, and it's the case that this book is about. Who's Monet? By the way, that's M-O-N-E-T, as in the artist Monet. So here we go. Plaintiff Gerda Dorothea DeWerth seeks the return from defendant Edith Marks Baldinger of a painting by Claude Monet entitled Champs de Bleu Vital. Mrs. DeWerth is a citizen of the Federal Republic of Germany, and Mrs. Baldinger is a citizen of the state of New York. The Monet, which is the subject of this action, is an impressionistic depiction in oil of a wheat field, a village, and trees in France. It measures 65 centimeters by 81 centimeters and is signed and dated Claude Monet, 79. Mrs. DeWerth's father, Carl, purchased the Monet in or about 1908, and he thereafter kept it in his house in West Germany. Plaintiff inherited the Monet from her father after his death. In the division, with the exception of the years 1927 to 1929, when the Monet was kept in her mother's house, plaintiff kept the Monet in her residence from 1922 to August 1943, where it was on display on a wall next to a sculpture by Auguste Rodin, who also inherited from her father. It's interesting, right off the bat, I'm looking at this art inherited from the father. Anyway, This sculpture is still in plaintiff's possession at her West German residence, and plaintiff has submitted a 1943 photograph showing the Monet and Rodin displayed together in her residence. From that time until the present, she neither sold nor otherwise disposed of the Monet, nor did she entrust the Monet to anyone else to sell or otherwise dispose of it. In August 1943, during the Second World War, Mrs. D. Worth sent the Monet, along with the Rodin sculpture and other valuables, by van to her sister in southern Germany for safekeeping. Although the van arrived, plaintiffs never saw the Monet again. In the fall of 1945, Gisela von Palm informed plaintiff of the disappearance of the Monet from Mrs. von Palm's house. There is no direct evidence as to what caused the disappearance of the Monet. American soldiers were quartered in the house after the close of the war in 1945, and it was after they had left that its disappearance was noted. I infer that either one of those soldiers or someone else stole the painting from von Palm House where it had been sent for safekeeping. Mrs. De Worth was approximately 50 years old when she learned of the Monet's disappearance. Subsequently, she made efforts to locate it. In 1946, she reported the loss of the Monet to the military government then administering the Bonn-Cologne area after the end of the war. In 1948, she solicited the assistance of her lawyer in attempting to find and recover it. Plaintiff also made inquiries in 1955 of one Dr. Alfred Spain, known to Mrs. D. Worth as an art expert. In 1957, she reported the Monet as missing to the West German Federal Bureau of Investigation in Bonn. All of these efforts to find the Monet were unsuccessful. By December 1956, however, the Monet has found its way to the United States through Switzerland. Wildenstein & Company, an art gallery in New York City, appears to have acquired the Monet on consignment from Francois Reichenbach, an art dealer from Geneva, Switzerland, in about December 1956. From December 56 to June 57, Wildenstein had possession of the Monet in New York. A Wildenstein record shows a 1962 payment or credit to Reichenbach, evidently for the Monet. In June 57, Wildenstein delivered the Monet for inspection to Mrs. Baldinger at her residence, Park Avenue, New York. Mrs. Baldinger, after several days, purchased the Monet in good faith and for value from Wildenstein on or about June 1957. After its purchase by Mrs. Baldinger, the Monet was publicly exhibited only on 2 occasions. Mrs. Baldinger exhibited the Monet at a benefit held in the Waldorf Astoria Hotel, New York City, from October 29th to November 1957, and loaned it to Wildenstein for display at a Wildenstein exhibition entitled 100 Years of Impressionism, held in 1970 at its gallery in New York City. At the close of this exhibition, Wildenstein returned the Monet to Mrs. Baldinger. Except for those 2 exhibitions, Mrs. Baldinger maintained the Monet exclusively in her residence on Park Avenue, New York City, from June 1957 to the present date. There are only 4 published references to the Monet in the art literature. 2 of them are in catalogs in connection with the exhibitions already cited, and the other 2 are in publications with which Wildenstein apparently connected. Almost done, folks. Hang in there. In or soon after July 1981, plaintiffs, through the efforts of her nephew Peter van der Hayt, discovered that the Monet had been exhibited in 1970 at the aforementioned Wildenstein loan exhibition. Plaintiffs thereafter retained counsel in New York in 1982 to determine whether Wildenstein knew the identity of the present possessor of the Monet. When Wildenstein refused to disclose the possessor's identity or the Monet's whereabouts, plaintiff commenced the proceeding in November 1982 against Wildenstein in New York State Supreme Court, seeking disclosure to aid in bringing an action On December 1st, 1982, the state Supreme Court found for the plaintiff, ordering Wildenstein to reveal the identity of the possessor. Plaintiff thereafter learned that defendant Baldinger possessed the Monet. By letter to Baldinger dated 1982, plaintiff demanded return of the Monet. By letter dated 1983, Baldinger refused the demand. Then the action ensued. Why did I bring up this case? This case is a foundational case in the concept of art, or let's see, there's a movie that came out recently called Monuments Men, and what the movie was about is preserving artwork or things like that were being stolen by the Nazis. But the whole point is that the concept of art itself, and the fact that who owns, I mean, this woman, the plaintiff owned it. Her family owned that piece of art, but it was stolen from her house, her residence, her sisters, I should say, during the war. And now she's actually pursuing a cause of action to recover what she believes was still her property. Now, the reason this is important is because about 5 years ago, I learned, I was just kind of looking through some old Catholic dictionaries. I learned that the Catholic dictionary defined child, C-H-I-L-D, as Christian art. So in the Catholic world, a child was considered Christian art. Now, it depends, I suppose, if it's a child of God, but there's something else to be said as to why would the Catholic Church define a child as art. It depends. I mean, is it the biological child they're defining, or is it the characterization, the biblical concept of a child of God? Well, what's interesting is that, and I'm not going to go too far into this, but in 1582, the Roman Catholic Church under Pope Gregory created a new timeline or a new calendar. And that calendar is known as the Gregorian calendar or the Anno Domini calendar, the AD calendar. I call it the Jesus fish calendar. And interestingly enough, they actually have a copyright. That is their calendar. They created it. It's their timeline. So here's the thing. This is what I actually believe is going on as well, is that the characters born to that Gregorian calendar are subjects or fictitious characters or the property, the literary property of the Roman Catholic Church. I'm talking about art, fictitious characters or art, or what I'll call a child under their definition, Christian art. That would mean that all of the persons born to the Anno Domini, i.e. Gregorian calendar created in 1582, every person created through that calendar, meaning Curtis Richard Kallenbach, born September 19, 1960 A.D., is a child under the literary property claim of the Roman Catholic Church. Now, just as an aside, and again, as Christian art, so I would advise anybody to read the idea of, or read Who's Monet. It's a great book, by the way. It really lays out a bunch of stuff as to possession when it comes to such a thing. But here, let me look up literary property real quick, because again, the timeline, the calendar itself is intellectual property. It's a claim. There's a claim upon that timeline. Again, Harry Potter, J.K. Rowling owns the world of Harry Potter. She owns all of the characters in all of the books of Harry Potter. So she owns Harry Potter. The Roman Catholic Church, because the character Curtis Richard Kallenbach was born to their literary property called the Gregorian calendar. That character is born and is within the world of, or on the timeline of, the Roman Catholic Church. They have a legitimate claim to that property. I'm talking literary property now. But I'm going to do one other thing here. I wasn't intending on doing this. But I'm going to go to Black's Law, and I'm going to do literary property real quick. Literary property is a scary, scary definition when you understand it. Here it is, page 841. Literary property may be described as the right which entitles an author and his assigns to all the use and profit of his composition, to which no independent right is, through any act or omission on his or their part, vested in another person. Literary property is the exclusive right of owner to possess, use, and dispose of intellectual production. The term denotes the corporeal property in which an intellectual production is embodied, and it may consist of letters, lectures, sermons, or addresses. Why is that so scary to me? When I see it says the term denotes the corporeal property in which an intellectual production is embodied. If I go around wearing the clothing of the character Harry Potter, J.K. Rowling, the author and owner of that character, has a right to my physical body as long as I'm clothed in that character. Until I take off the clothes of Harry Potter, she can tell me, as the director or the owner, what to do. That's her property. No different than the Roman Catholic Church can tell me what to do while I'm wearing the character Curtis Richard Kallenbach. It's no different. Curtis Richard Kallenbach, Harry Potter. Two different owners, but the same idea. It's literary property. So that was an aside. What I was really getting at is the concept of my child. My child. And this was something that somebody asked me to do. I had about half a dozen people over the last week or so ask me to describe the case that occurred with my own son, Alex. So what I'm going to do is I have another idea later on to finish up and close this out. But I want to go ahead and I want to talk about my son's case for a bit, because when people understand how much power a father has over his property. By the way, I would advise everybody just go ahead and open up pCloud. And I'm going to go ahead and read the letters that I created for my son. First, let me tell you what happened. My son was coming home from work late. I don't know whether he was drinking or not. That's not relevant. But he was coming home. He was driving between Madison, Wisconsin, and Monroe, Wisconsin. And it's a good hour between those places. And somewhere between Madison and Monroe, he had crossed the center line. Now, it was 1 o'clock in the morning, and he told me he was tired. And the cop, I believe it was the deputy sheriff that pulled him over, did not cite him for any alcohol. But he did cite him for crossing the center line. So my son, I don't even know if he for some reason ended up in jail that night. I don't know that he got home. But he was pretty scared about it. It was the first time he'd ever been stopped. So he called me the next day, and he told me what had happened. And even though for the last 7 years my own son has thought I've lost it, Dad's completely whack, he asked me, he said, you know what, why don't you try some of your stuff to see if it'll have any effect on this. I'll give you a month or so. So I said, okay. So here's what I did. I had an idea. And my idea was basically to claim my son as my property. Okay? So I have, if you go to Alex, Wisconsin, AG, that is the first letter that I generated. And what I did is I wrote letters to the Wisconsin Attorney General, obviously the court, the county court, the Catholic diocese of my county, because I'm within that diocese, even though I'm not a Catholic parishioner. Well, I'm not, but I am within the county of this particular diocese. So I wrote to the chancellor of the diocese in Rockford. So I wrote, I believe, 3 letters. I mean, it's all the same letter, but I sent them to 3 different places. Here's the first letter, and this one, the 3 letters that I posted are actually to the Wisconsin Attorney General. Dear Attorney General, please refer to the included registered letter to Greene County Circuit Clerk. By the way, I always use registered letters. I know a lot of people are cheap bastards, and they don't understand that cheap gets you cheap. I prefer to use things that I know work, and I prefer to use things that are coming from outside to go inside. In other words, outside the snow globe to go inside the snow globe. If you're using certified letters in domestic mail, you're inside the snow globe. So it says, the registered letter to Greene County Circuit Clerk, and immediately update or expunge all records, lists, etc., regarding the individual birth certificated foundling person known as Kiefer Alexander James Kallenbach, to make clear to all potential claimants the truth of the matter in question. It, foundling, has from the beginning been private, allodium within my absolute solo dominion and trust. Through many years of unnecessary suffering and erroneous beliefs leading me to the actual possession of true knowledge, it has been my experience to never trust another with any of my private property. I know that sounds horrible, but what you'll realize is that this is all about believing somebody's trustworthy when they in fact are not. There's nobody I know that realistically should be burdened with my life. There are people that would be willing to take it on, but ultimately I would prefer not to trust anybody with my life because it's not as important to them as it is to me. Okay? Webster's 1828 dictionary, I covered it last night or the night before. Certificate. The key there is the verb transitive where it says to give a certificate, to lodge a certificate with the proper officer for the purpose of being exempted from the payment of taxes to support the ministry in a parish or ecclesiastical society. 2, to give a certificate. 2, acknowledging one to be a parishioner, but such certificate the person can gain no settlement. And then I started using Black's Law definitions. I put the definition for a foundling. The definition for the foundling hospitals, the definition for allodium, land held absolutely in one's own right and not of any lord or superior, land not subject to feudal duties or burdens, an estate held by absolute ownership without recognizing any superior to whom any duty is due on account thereof. Dominion. This is me stating my position, by the way. You'll see it real quick. Dominion. Generally accepted definition of dominion is perfect control in right of ownership. The word implies both title and possession and appears to require a complete retention of control over disposition. Title to an article of property which arises from the power of disposition and the right of claiming it. Sovereignty as the dominion of the seas over a territory in the civil law with reference to the title to property which is transferred by a sale of it. Dominion is said to be either proximate or remote, the former being the kind of title vesting in the purchaser when he has acquired both the ownership and the possession of the article, the latter describing the nature of his title when he has legitimately acquired the ownership of the property, but there has been no delivery. True. Comfortable, to fact, correct, exact, actual, genuine. That's a key word right there, people. Genuine, honest. In one sense, that only is true which is comfortable to the actual state of things. In that sense, a statement is untrue which does not express things exactly as they are. But in another and broader sense, the word true is often used as a true synonym of honest, sincere, not fraudulent. I think I went through sincere, sincerera last week, meaning without wax. You know, while I'm doing this real quick, true, that definition of true is pretty amazing. But how many people in their experience along the way have run into the words true copy? True copy on their documents, the ones that the county produces or the ones that are certified. This is another aside, but it's pretty important to see what Black's Law can do to the language. So true, I just read true, comfortable to fact, correct, exact, actual, genuine, honest. But look what it says for true copy. True copy does not mean an absolutely exact. An absolutely exact copy, but means that the copy shall be so true that anybody can understand it. Let me say that again. So a true copy, if you look at your birth certificate, it might even say a true copy. But look what a true copy is. A true copy does not mean an absolutely exact copy. Well, under the word true or the definition of true, it says exact. So in order for it to be true, it has to be exact. And yet true copy says a true copy does not mean an absolutely exact copy, but means a copy that shall be so true that anybody can understand it. What the hell does that mean? Well, it means that a true copy is not true. So when you see that on those government-issued documents, or actually I don't believe it's the government, to be honest with you, but a true copy means not true. Next word was experience. A state, isn't that funny? The word experience means a state, extent or duration of being engaged in a particular study or work. The real life as contrasted with the ideal or imaginary. A word implying skill, facility, or practical wisdom gained by personal knowledge, feeling, and action, and also the course or process by which one attains knowledge or wisdom. So experience actually says real life as contrasted with the ideal or imaginary. It also says experience is what? Gained by personal knowledge. So knowledge, it's saying that experience and knowledge are the same. Anyway, property. That's a little too long for me to read at my pace. But it does say that which is peculiar or proper to any person. That which belongs exclusively to one. That's property. Criminal code. Property means anything of value, including real estate, tangible or intangible personal property. Contract rights. Chooses an action and other interest in or claims to wealth, admission or transportation tickets, blah, blah, blah. Trusts. Absolute property. In respect to chattels, personal property is said to be absolute, where a man has solely and exclusively. It doesn't say a person here. It says where a man has solely and exclusively the right and also the possession of movable chattels. In the law of will, the bequest or device to be the absolute property of the beneficiary, blah, 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 in common property. A term sometimes applied to lands owned by a municipal corporation and held in trust for the common use of the inhabitants. Also property owned jointly by a husband and wife under the community system. Wow. Also, this is going to come into play later tonight, by the way. Common property. Also property owned jointly by husband and wife under the community system. So here's what I finished up with. It says, finally, I have found that when dealing in matters of truth, it always seems that the so-called facts get in the way. Thank God I have the facts of the matter in my physical possession. Have a wonderful day. Sincerely, Curtis Kallenbach, father and private citizen. Now, of course, this was probably, if he's 24, this is almost 3 years old. This is the first letter I sent. basically laying down an idea. So this is AG1. I think a week passed, 6 to 8 days later, I sent AG2. So what did AG2 say? Now remember, I got no response on any of these letters. Not a single one. I never got a response from anybody. Letter 2, it went out about 6 to 8 days later. Dear Attorney General, please refer to included registered letter to Greene County Circuit Clerk and immediately update, expunge all records. Basically the same idea, but I changed the second paragraph. It says, as one can plainly see by the included document copies, I have and hold a federally authenticated or genuine certificate of live birth and certification of birth, as well as an a priori paramount claim and declaration evidencing my true and actual knowledge of clear legal right and absolute dominion upon the entirety of my life, time, space, land, product, and natural appurtenances or life. Black's Law. To hold. Now I'm positioning myself. To hold is to possess in virtue of a lawful title, as in the expression common in grants, to have and to hold. Where else do we hear to have and to hold? Don't we hear that in like a wedding vow? So to hold, it says common grants, to have and to hold. Now I'm not going to read that whole thing either. And then, of course, the second definition is clear legal right, where it says a right inferable as a matter of law from uncontroverted fact. And so my last statement here was, again, I do not tolerate trespass upon my private property, and I do not in any way sacrifice my precious time, my precious private time or property to any erroneous claims, causes, or cases. Should you or any other person dispute, disagree, or contest any of my aforementioned statements or claims, by the way, when I say contest any of my aforementioned statements or claims, that includes the first letter. It includes the first letter. So any of my aforementioned statements or claims, I will accept written rebuttal evidence within 10 business days receipt of this registered letter. Failure to respond within the time allotted will be considered a tacit agreement and full acceptance to all as written. So this letter and that letter are now covered. The registered letter is notice of truth and fact regarding all matters in question ab initio, in other words, from the beginning. So this letter was the second letter that went out. Now the third letter, I wanted to close the door. I gave them, this will be the third opportunity for them to do the right thing. Again, please refer to registered letter to Greene County Clerk. Okay? I used the same paragraph, opening paragraph, 3 times in a row, so they would not mistake what I was speaking of. Next paragraph. As you can clearly see for yourself by my previous writings, Attorney General Schimmel, I am quite serious about the continued trespass upon my private property. Even the written words of Pope Leo VIII in his Rerum Novarum, the encyclical of Pope Leo VIII on capital and labor, support my claim as the father. To wit, it is a most sacred law of nature that a father should provide food and all the necessaries for those whom he has begotten. And similarly, it is natural that he should wish that his children, who carry on, so to speak, and continue his personality, should be by him provided with all that is needful to enable them to keep themselves decently from want and misery amid the uncertainties of this mortal life. Now, in no other way can a father effect this except by the ownership of productive property, which he can transmit to his children by inheritance. A family, no less than a state, is, as we have said, a true society governed by an authority peculiar to itself, that is to say, by the authority of the Father. The church is now laying down that it's the Father that has all the power. But this is both of these quotes are out of the Rerum Novarum. And, next quote, paternal authority can be neither abolished nor absorbed by the state, for it has the same source as human life itself. The child belongs to the father and is, as it were, the continuation of the father's personality. And speaking strictly, the child takes its place in civil society, not of its own right, but in its quality as a member of the family in which it is born. And for that, and for the very reason that the child belongs to the father, it is St. Thomas Aquinas says, before it attains the use of free will under the power and the charge of its parents. Also, Attorney General Schimmel, the legal separation of church and state may work upon public lands just fine, but absolutely does not apply to my private land or property. Only a truly ignorant man would allow such a separation, for it would in fact result in a heart-mind split within himself, creating a house divided, to wit. A house divided against itself cannot stand. I believe this government cannot endure permanently half slave and half free. I do not expect the union to be dissolved. I do not expect the house to fall. But I do expect it will cease to be divided. It will soon become all one thing or all the other. Either the opponents of slavery will arrest the further spread of it and place it where the public mind shall rest in the belief that it is in the course of ultimate extinction, or its advocates will push it forward till it shall become lawful in all the states, old as well as new, north as well as south. That's Abraham Lincoln. And so Jesus called them over to him and began to speak to them in parables. How can Satan drive out Satan? If a kingdom is divided against itself, that kingdom cannot stand. If a house is divided against itself, that house cannot stand. And if Satan opposes himself and is divided, he cannot stand. His end has come. In fact, no one can enter a strong man's house without first tying him up. Then he can plunder the strong man's house. Truly, I tell you, people can be forgiven all their sins and every slander they utter, but whoever blasphemes against the Holy Spirit will never be forgiven. They are guilty of an eternal sin. So I close with, should you, Attorney General, or any other person choose to dispute, disagree, or contest any of the aforementioned statements or claims, I will accept written rebuttal evidence within 10 business days receipt of this registered letter. Failure to respond within the time allotted will be considered a tacit agreement to all aforementioned statements via acquiescence. Although Greene County, Wisconsin may attempt to commingle my private property with their public affairs, this coming Monday, June 29, 2015, at 9 a.m., I find this private matter closed and will not be a willing participant. This registered letter is notice of the truth and fact regarding all matters in question ab initio. Sincerely, Curtis Kallenbach. So here's what happened. I heard nothing. 3 letters out, not a single word back from anybody. I believe there were at least 3 separate recipients. I sent out 9 registered letters and received nothing from anybody. Do not ever expect to get anything from these people. Ever. The only time I ever got anything from anybody was that last letter I sent to the alien property custodian calling me friend. That's the only thing I ever received from anybody. Well, that's not true. I did get 1 letter back from Interpol. They sent back my letter saying that they didn't have anything to do with the particular matter I was speaking about. But I sent out, between my wife's stuff and my stuff registered, I sent out 200 registered letters, at least. And I never got 1 response. I got 2. 1 from the APC and 1 from Interpol. Nobody else ever responded. Do not expect anything from these people. There's no honor there. That would be an admission of guilt. So here's what happened. Nothing. Nothing happened. So my son got another letter in the mail saying that he had to appear before somebody in Greene County Court, and he was scared. He's 22 years old, I think, at the time. Yeah, 22. I told him to do whatever he wanted to do. I'm not going to tell him what to do. He has to make up his own mind. So he ended up saying, Dad, I'm going to go get an attorney. I said, son, I'm proud of you. Take care of it any way you want. He interviewed a couple of attorneys, found one he felt comfortable with, paid the guy, jumped through all the hoops, appeared at all the things, and in the end, the case was handled by what always appears to us to be handled. Well, he had no points on his insurance and all that garbage, so he was pretty happy with the outcome. Cost him probably somewhere between $800 and $1,500. About, I don't know, 2 months later, he calls me up. I mean, we spoke in the meantime, but I'm saying about this issue. He calls me up and he says, Dad, you're not going to believe who just called me. I said, who? And he says, my attorney. I said, oh, no, now what? Because I'm afraid something is going wrong at this point. He says, the attorney just told me that my case was dismissed. I said, what are you talking about dismissed? It was already adjudicated. The damn thing's been done for, 3 months? He says, no, the attorney said it was dismissed. I said, well, that's the funniest thing I've ever heard. How can a case get dismissed after it was already done? Well, I also posted at PCloud the letter. When I went online to look up my son's case, the first one from Wisconsin Circuit Court Access, it says Greene County versus Kiefer Alexander James Kallenbach. It says the defendant was charged with the following offense. I guess it does. It looks like it says OWI, operating while intoxicated, maybe, I don't know. There was a finding of, and then it says action, dismissed on prosecutor's motion. Prosecutor's motion. How did that happen after the case was already closed? I already know why, and I'm going to explain why it happened. But then I also have another one here. If you go to the next one, the other dismissal, it says all charges against Kiefer Alexander James Kallenbach in this case have been dismissed. These charges were not proven and have no legal effect. Kiefer Alexander James Kallenbach is presumed innocent. Innocent. That's very rarely do you see that word. Why did this happen? It happened because that court had no jurisdiction whatsoever over my son. It took that long for them to figure out what the hell I was saying. So in the meantime, my son, who had no authority to go beyond my authority, I haven't released my son yet. I haven't said it's okay to do anything, even though I told him it was okay. I obviously was telling that court, that world, that as the father of that son, of my son, I am not allowing that to happen, that world to happen. It took them a while, but they finally realized their error. They had no jurisdictional authority over my son. And they dismissed the case. That's the only thing they could do. What's interesting about this, though, is for those of you that will read the Rerum Novarum by the Pope, what I'm going to tell you right now is that in that Rerum Novarum on capital and labor, which I'm going to use later with the industrial property of Paris 1883, but Rerum Novarum is making the case for the father to have all the authority, period. Now here's the thing. If a father does not claim his family, there is another father waiting in the wings. And that father is the vicar of Christ called the Pope. So when a man doesn't claim his family and doesn't stand his ground as the father, there's another father waiting to take his place with all the same authority. So this Rerum Novarum also applies to the Pope. And he has all the same power as I do. When the biological father does not make the claim, the Pope, by default, becomes the father of that family. This rerum novarum works for both the biological man standing his ground and the Pope by default. That's the way it's written. I would advise every dad, every father, for sure, to read this with really a nice, calm set of eyes, because it's important to know this stuff. But again, I was standing my ground as the owner of Alex's life. I'm taking it a step further in the next week or so, where I'm actually claiming his name back and putting it under my name. So if anything ever happens commercially, that property's mine. And they can never speak to my son about any commercial issue, because my son is now on my ark, my commercial ark. And so is my wife. As the father, I get to rule. I know that sounds pretty tough for some ladies, but you know what? I bet most women would love to have a man be able to defend their asses. And it would be really nice for a man not to lose his children to DCFS. That's what I'm talking about here, people. They have emasculated the American people. They have emasculated. There are no men left. Legally, there are no men left. We've lost the right to do anything. So where am I on this? It's all about whose property is it and who can prove it. You know what? There's no possible way, with the way I was writing that they're going to say anything against me. They didn't have a legitimate claim. I came forward and I wrote this stuff. Now, would I use the same format and do the same way today, knowing what I know today? No. But it's live and learn. It's live and learn. So I defended my child. What's really funny about this stuff is there's always a bunch of great movies out there regarding our children. One of my favorite movies, as brutal as it is Liam Neeson in the movie Taken. And the movie Taken, it's about the man's property being taken from him. And he has the definite skill set to recover that property. I don't have the same skill set, but man, I sure would like it. So let's keep going here. It's always about the claim. I mean, everything I've been talking about is it's a claim or it's not a claim. If we don't claim our property, they're going to presume it's abandoned. Everything is about this presumption of abandonment. Whether it's on the land or at sea or on the beach, it's property that was abandoned and picked up by somebody else and claimed. So let's start with the word claim. Claim. Black's Law, page 224. 224. Claim. To demand as one's own or as one's right. To assert, to urge, to insist, which is a cause of action. Remember, I tell you right now that without a claim, there is no cause. Without any cause, there is no case. So if you can negate the very claim, if you can make it so there isn't even the possibility of a claim from somebody else, from another position, no claim, no cause, no case. It really is that simple. No claim, no cause, no case. You eliminate the claim, you eliminate the case. Means by or through which claimant obtains possession or enjoyment of a privilege or thing. Remember that your physical body is a thing. And that thing has a name or a title. Do I have a name or a title? No. But does my body have a name or a title? Yes. I am the spirit that animates the body. The body has a name. Names are for things. But a name is not for I. So a claim is to demand as one's own or as one's right. I would say that every father has a legitimate claim upon his children. And he should absolutely assert, urge, or insist on that claim. So cause of action. A cause of action. What page is cause of action? Cause of action. Page 200. No, 201. The fact or facts which give a person a right to judicial relief. The legal effect of an occurrence in terms of redress to a party. To the occurrence. A situation or state of facts which would entitle party to sustain action and give him right to seek judicial remedy on his behalf. Look at this. It says entitle party to sustain an action. If you don't have a proper claim, if you don't have a real right to the property, it says a situation or state of facts which would entitle a party to sustain an action and give him right to seek judicial remedy. Can anybody else do that with my son other than my wife or my ex-wife? No. Then how does it happen with DCFS in the state? Cause of action is a fact or the fact or facts. So let's look at fact. Page 531. 531. Fact. A thing done, an action performed, or an incident transpiring, an event or circumstance, an actual occurrence, an actual happening in time, space, or an event, mental or physical. That which has taken place, that's a fact. A fact is either a state of things, that is, an existence, or a motion, that is, an event. The quality of being actual existence or occurrence. Isn't that funny? You never think of a legal dictionary or a Black's Law dictionary as using the idea of time and space. Time and space. So what was the key word in there that I noticed? And that would be circumstance. Circumstance. What page is that? Page 220. Circumstance. Okay, 220. Circumstance. Attendant or accompanying facts, events, or conditions, subordinate or accessory facts, evidence that indicates the probability or improbability of an event. Here's what caught my eye. It says, as used in a statute for an allowance for the wife in a divorce action, having regard to the circumstances of the parties. I was thinking, okay, wait a minute here. Why are they putting the idea of a divorce in this? What is it that they're trying to accomplish? Why are they bringing up a divorce in the circumstances? I already knew what they were doing. See, I know that Ignatius Loyola, who created the Society of Jesus known as the Jesuits, see, I know that their goal is to separate the spirit or the soul of man from the body. And I also know that that separation is also called separation of church and state. But I also know when I see the word divorce that they're trying to be specific. Something is being separated from something else, even though they use the word wife here. It says an allowance for the wife in a divorce action. Because they didn't use both husband and wife or anything like that, I knew that they were being specific to something that implies a wife or has maybe a different meaning of wife. So I'm going to look up divorce to see what their meaning or where it can take me. Divorce is page 431. I have so many markers in my book. I mean, every time I turn a page, something falls out of it. 431. Okay. Divorce. And by the way, please do yourself a favor and don't think you know what these definitions are. Please go look them up. Don't think you know what a divorce is until you see the words and start to contemplate all the possibilities within that definition. Just like when Bill Clinton says, it depends on what the definition of is, we all laughed when he said that. But he knew what he meant. And he was telling the truth. We just thought he sounded like a moron. What he was saying is, all you people are morons. Divorce. I wish everybody could actually answer this question, because I'm going to answer a question here. I'm going to ask a question, and I wish it could be answered. Divorce. The legal separation of man and wife affected by the judgment or decree of a court, and either totally dissolving the marriage relation or suspending its effects so far as concerns the cohabitation of the parties. I'm wondering if anybody sees anything in there that seems a little odd. See, I'm going to read it again, and then I'm going to point something out, and I bet that a lot of light bulbs go on here. It says divorce. The legal separation of man and wife affected by the judgment or decree of a court, and either totally dissolving the marriage relation or suspending its effect so far as concerns the cohabitation of the parties. I have a feeling that everybody thought cohabitation was the key word, and it is. But it's not the thing that jumped out at me. The thing that jumped out at me is that the legal separation of man and wife. It doesn't say man and woman or husband and wife. See, those two go together. Husband and wife go together, and man and woman go together. So why the hell did they mix these metaphors? Why did they mix man and wife? Because wife denotes something different than woman. Wife means something ecclesiastical to a man. Wife means something religious. And then the idea of its effects so far as concerns cohabitation. So when you understand that a man not cohabitating with the wife, not the man not cohabitating with the woman, but not cohabitating with the wife, means something entirely different. So let's just look up cohabitation real quick. Page 236. 236. Cohabitation. Now it says to live together as husband and wife. Well, it seems like they corrected that. But it says to live together as husband and wife. So to live together is what I'm looking at. So when you're not cohabitating, you're separated. You're not living together, which means a bond has been broken, or there's a separation between. And the first one said man and wife. So there's a non-cohabitation between a man and wife. Let's go biblical. Let's go biblical. What is a wife but a bride? I think there's a document in P-Cloud. I looked up. See, I'm always thinking about the separation of church and state. See, I know that the concept of the church, where is this? Here it is right here. I looked up the bride, the word bride, biblically. And it says the bride of Christ, or bride, the Lamb's wife. The Lamb's wife. So the bride, the wife of a man, or the wife of I am, i.e. the Christ, or the bride. I'm using all these different terms to mean the same thing here. The Lamb's wife. Okay? The Lamb's wife is a term used, and this is, by the way, at Wikipedia under Bride of Christ, if you're going to follow along. Wikipedia, Bride of Christ. The Bride of Christ, or bride, is the Lamb's wife, is a term used in reference to a group of related verses in the Bible. In the Gospels, Revelation, and the Epistles, and related verses in the Old Testament. Sometimes the bride is implied by calling Jesus a bridegroom. And here it is. What is the bride of Christ? For over 1,500 years, the church was identified as the bride, betrothed to Christ. So the church is the wife of the man. The church is the wife of the man. So what I did is I looked up, I hit the hyperlink church there, and it brought me to Christian church. And it says the Christian church is a term generally used to refer to the whole group of people belonging to the Christian religious tradition throughout history. So what I did is I put a PDF together. By the way, the word church also, in Greek, it means ecclesia. So wherever you see the word ecclesia, and it's in Black's Law, by the way, it means church. Okay, so what I did at P-Cloud is, if you want, it would be smart to go to what is the church. And I put together something there that eventually is going to get kind of strange. And this is written by a scholar, a religious scholar, which, no offense to anybody, but it almost seems like an oxymoron. Call somebody a religious scholar. That's like calling somebody a Harry Potter scholar. I mean, how can you be the scholar of a fiction? There's something weird about that to me. I mean, why would I be a scholar to Charlie Brown? Do I really need to know the depths of Charlie Brown, to the point of having a PhD in Charlie Brown? Do I need a PhD in Harry Potter? I'm sure that they probably offer it, but I know they offer PhDs in religion. What is the church? This is an amazing read, by the way. I'm not going to read it because it's 21 pages long with everything I added to it. It's not a lot, but it's there. But I am going to read what is the church. It says, if you were to ask people what they think of when they hear the word church, you would get many different responses. Some responses may be accurate and some may not be so accurate. However, most people are surprised to learn what is the Bible definition of church and what is the biblical view of the church. What is the common definition of church? By the way, this is important because the separation of church and state, which everybody clamored for, a wall of separation, as Thomas Jefferson supposedly said, a wall of separation between church and state. A wall. A wall, a wall, a wall. Humpty Dumpty fell off a wall. We are divided. There's a piece of us on the other side of a wall. The only way to challenge all this is to tear the wall down and bring these pieces back together. Anyway, what is the common definition of church? The church is commonly defined as a building used for public worship. However, many people refer to the church as an organization. Examples are the Catholic Church, the Church of England, and the Southern Baptist Church, among many others. What is the Bible definition of church? The word church in the Bible comes from the Greek word ecclesia, which means a called out company or assembly. Called out. Wherever it is used in the Bible, it refers to people. Wherever it is used in the Bible, it refers to people. I'm not talking brick and mortar things here, people. It can be a mob, the children of Israel, and the body of Christ. We see the word church used three different ways. First is the body of Christ. The body of Christ. In my case, the body of Christ would be the physical body that's sitting in this chair right now yelling at you. The Christ is the I am. It's the present moment. It's me housed in this temple of God. My body is just the biological suit to which my I am spirit is housed. The church is often defined as a local assembly or group of believers. Second, it is defined as the body of individual living believers. Finally, it's defined as the universal group of all people who have trusted Christ through the ages. What the church is not. The church is not Jews or Gentiles. The church is not a kingdom. Some people try to make the church the kingdom of heaven that has already come. They ignore the following. The church inherits the kingdom. The church is here on earth, but the kingdom of heaven is not here. The church is not a physical building or business organization. Too often people describe a church building or organization as the church. This is because they emphasize the facility or organizational hierarchy as to what constitutes a church. Most churches are organized in such a way that the public face of the church is seen as a business. However, since many people have a difficult time putting a label on the church, the term local church is often used to denote the local assembly of believers along with their meeting place and operation. What is the biblical view of the church? The church is a building or temple of God. Although the church is not a physical building, believers are referred to as the building or temple of God. Let me say this again. Believers are often referred to as the building or temple of God. Like a physical building, believers also have a cornerstone, Jesus Christ. The foundation is the prophets and the apostles. The church is the bride of Christ. The Bible makes reference to the church being the bride of Christ. This is also alluded to in John 14 when Jesus talked about making a place at his Father's house for us. Father, Son, Holy Ghost. Mind, body, spirit. This is a direct reference to when a man proposes to a woman and they are engaged. The man goes back to his father's house to build on an addition. When the addition is done and everything is ready, he comes to call for his bride, which symbolizes the resurrection. Father, Son, Holy Ghost, you have to pull yourself together. The church has a spiritual purpose. Conclusion, and this is the most important aspect of this whole damn thing here. It says, when Jesus had dinner at Matthew's house, he was asked how he could spend time eating with sinners. When Jesus heard this, he answered with words that were very telling. He said, they that be whole need not a physician. I highlighted that because it's the most important thing that I can even imagine the Bible ever having printed in it. They that be whole, WHOLE, need not a physician. What does that imply? It implies that those that are not whole need to be healed. What is the concept of the Christ but a salve, a balm, a healing balm, something that actually heals up a chasm or an open wound? What is the wound? The wound is the separation of the divine masculine and the divine feminine. It's the space that is created through the separation of the church and state. The state is the masculine, the church is the feminine. Everybody screamed for that separation of church and state, and they got it, which is why it's always good to be careful for what you wish for. They that be whole need not a physician. What do you think is going on in that courtroom? They're healing you. They're redeeming you from the pits. Thank God those guys are there for you. Get out of this. I'm going to go to back to Black Law, and I'm going to start with the word proof. Remember, whose is it, and who can prove it? By the way, if you don't need to be healed, let me go back up to that before I go on to proof. It says, they that be whole need not a physician. Unum Sanctum says the spiritual man shall be judged by no man, but the human creature is subject to the Roman pontiff. Why? Because the spiritual man is whole, mind, body, and spirit in one place at the present moment. There is no separation of church and state. And he is judged by no man. You will not end up in a courtroom when you are whole. Because Jesus is the I am, the present moment. When you pull yourself into the present moment, you are healed. You have redeemed yourself. The concept of salvation is not necessary anymore. Only the sick or infirm or separated need to be salvaged. And this whole thing is about a salvage operation, let me tell you. By our own conviction. And the word conviction means strong belief. Okay. Proof. Page 1093. Proof. 1093. Again, this is all about whose is it and who can prove it. Proof. Here it is. Proof. The effect of evidence. The establishment of a fact by evidence. It says any fact or circumstance which leads the mind to the affirmation or the affirmative or negative of any proposition. The conviction or persuasion of the mind of a judge or jury by the exhibition of evidence of the reality of a fact alleged. Proof is the establishment by evidence of a requisite degree of belief concerning a fact in the mind of the trier of fact or the court. So I guess it says proof is the effect of evidence. Proof is an effect that's required that gives proof. So what is evidence? Evidence is page 498. 498. Oh, here it is. Evidence. This is a strange definition. Now, of course, it goes almost a page and a half, but I'm only going to read the very first paragraph. Evidence. Any species of proof or probative matter legally presented at the trial of an issue by the act of the parties and through the medium of witnesses, records, documents, exhibits, concrete objects, etc., for the purpose of inducing belief in the minds of the court or jury as to their contention. Inducing beliefs? Again, evidence. Any species of proof or probative matter. Probative matter. That sounds like afterbirth material to me. But anyway, any species of proof or probative matter legally presented at the trial of an issue. The trial of an issue. At the trial of an issue. Presented at the trial of an issue. What's on trial here? It says at the trial of an issue. I have to go to issue now. I don't know why. It's just that I know what it means, but issue, to send forth, to emit, to promulgate, as an officer issues orders, process issues from a court, to put into circulation, as the Treasury issues notes, to send out officially, to deliver for use, or authoritatively, to go forth as I'm looking for something specific here. Issue, a noun. The act of issuing, sending forth, emitting, or promulgating, the giving of thing its first inception, as the issue of an order of a writ. I know what I can jump to real quick. Don't lose the word evidence here. I'm not done with evidence. I'm going to go to another word that I believe means issue. Let's see. The word child. Child, progeny, offspring, or parentage. Unborn or recently born human being. At common law, one who had not attained the age of 14 years, though the meaning now varies in different statutes. Child, labor, support, criminal statutes. The term child or children may include or apply to adopted, afterborn, or illegitimate child, stepchild, child by second or former marriage. Issue. The very last word in that definition is issue. And it's funny, even afterborn, it says adopted, afterborn, or illegitimate child. So afterborn means issue, illegitimate child means issue, child means issue, progeny means issue, offspring means issue, unborn means issue, recently born human being means issue. Go back to evidence. Any species of proof or probative matter legally presented at the trial of an issue. The trial of an issue. I can't get past that. Presented at the trial of an issue. When you show up in court, what the hell's going on in there? About 50 things are going on, but the point is that the trial of an issue. When you look at the word child and you see progeny, offspring, unborn, recently born, adopted, afterborn, illegitimate, all stepchild, they're all issues. So it says presented at the trial of an issue by an act of the parties and through the medium of witnesses. I think that's strange all by itself, is the use of the word medium, almost like a seance. The medium of witnesses, records, documents, exhibits, concrete objects. But here's the thing. for the purpose of inducing belief. Almost like mesmerizing people. Inducing belief. I wonder if induce is in here. I'm not going to lose the word evidence because inducing belief shocked me when I read that way back when. Let's see if induce is in here. I know what seduce means. It doesn't happen very often. Let's see. Induce. Sorry for the bad jokes here. Induce is it here. Induct. Induce. To bring on or about. To affect. Cause. To influence. To an act or course of conduct. Lead by persuasion or reasoning. Insight by motive. Prevail on. With inducement in contract. The benefit or advantage which the promisor is to receive from a contract. Induce, in international law, a truce, a suspension of hostilities, an agreement during war to abstain for a time from warlike acts. Induct, to put in enjoyment or possession. To put in enjoyment or possession. Especially to induce into possession of an office or benefit with customary ceremonies. To bring in, initiate. To initiate. To induce is to initiate. To begin, to commence a belief. Initiate, to put formally in possession. To enter formally into military service. To inaugurate or install. To induce belief. And here we're going to go. We're going to see about what happens with belief. Belief. Page 141. Where does that take me? 141. Belief. A conviction of the truth of a proposition existing subjectively in the mind and induced by argument, persuasion, or proof addressed to the judgment. Let me say that again. Addressed to the judgment. A conclusion arrived at from external sources after weighing probability. Conviction of the mind arising not from actual perception or knowledge, but by way of inference or from evidence received or information derived from others. I got to say that again. I hope it didn't pass you. Conviction of the mind arising not from actual perception or knowledge, but by way of inference or from evidence received or information derived from others. Knowledge is an assurance of a fact or proposition founded on perception by the senses. So let me go back up to conviction of the mind arising not from actual perception or knowledge. Conviction of the mind arising not from the actual perception or knowledge. What's knowledge? Knowledge is an assurance of a fact or proposition founded on perception by the senses or intuition, while belief is an assurance gained by evidence and from other persons. So let me say this again about belief. Everything that's going on is to induce belief in that courtroom. Induce belief. But belief is not knowledge. What does it say here again? Conviction of the mind arising not from actual perception or knowledge. So you're being convicted. Conviction is a strong belief, but what is it? You're being convicted. You have a conviction that is not based upon actual perception or knowledge. And it says knowledge is an assurance of a fact or proposition founded on perception by the senses. Reality, people. They're actually saying that such a conviction is when you're not in reality. You're not living in reality. They're saying it right here under the definition of belief. Conviction of the mind arising not from actual perception or knowledge. And then they're going right in the next paragraph saying knowledge is an assurance of a fact or proposition founded on perception by the senses. That means it's nonsense. Belief is nonsensical. You are unreasonable in the courtroom when you're basing or you have a conviction that is not based on knowledge. It's nonsense. Nonsense. I always like to tell people that, they can believe whatever they want. I joke about this all the time, and it is horrifying, but think about this. There are people out there, God bless them, but there are people out there that actually believe that the world we live in is a hologram. Oh, Kurt, my God, don't go there. David, I just taught it so much. The world we live in at some level may be a hologram, but the world at the level at which we live in it, with our biology and the molecular structure and everything that we live by, is not a hologram. When you step in front of the train, it doesn't pass through you, regardless of how much you believe it will. Belief is nonsensical. The same, well, Kurt, I can go without oxygen. I'm here. I'm just this of a spirit, blah, 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 blah. And then all I have to do is place the plastic bag over your head. And all of a sudden, knowledge creeps into your brain for the short period of time it has left. Because your senses are telling you you need oxygen, regardless of your belief. The idea of salvation is a belief. And the courtroom is looking at you and thinking that you are nonsensical. If you believe in such nonsense, you really need to be institutionalized. And you need to stay where you are, and the United States of America does not want you. You are lacking legal capacity at this point. I'm going to go with belief one more time here, and I'm getting out of here. I'm going to close up with a couple of things. I was going to try to get back to Haslam versus Lockwood, but I have all week to do that, at least 2 more days. Belief. I'm going to go to knowledge. I'm going to close with knowledge then, because knowledge is important. By the way, knowledge equals information. Information is provided by mother as informant on the birth record. The birth record is considered information. It's also considered knowledge. The birth record is knowledge of your existence. You have to find a way to reconnect to that knowledge. Belief isn't going to help you. Belief, a conviction of the truth of a proposition existing subjectively, not objectively, subjectively, in the mind and induced by argument, persuasion, or proof addressed to the judgment. A conclusion arrived at from external sources after weighing probability. A conviction of the mind arising not from actual perception or knowledge, but by way of inference or from other evidence received or information derived from others. Information derived from others. So when that judge is holding that piece of information that's going to convict you, and you agree with him, you understand what he's saying. It says knowledge is an assurance of a fact or proposition founded on perception by the senses. It's objective. You can see it. You can smell it. You can touch it. It's real. It's substantial. It's your body. It's reality. While belief is an assurance gained by evidence and from other persons. Suspicion is weaker than belief since suspicion requires no real foundation. I suspect. Why do they call you a suspect? It says suspicion is weaker than belief since suspicion requires no real foundation for its existence, while belief is necessarily based on at least assumed facts. Assumed facts. Before I go to knowledge, I'm going to go to assumed. We all grew up with that. How do you spell assumed? Well, it makes an ass out of you and me. That's one way to remember how to spell assume. Assume. Assumed facts. That's almost an oxymoron right there. Assumed. Page 112, blacks. To pretend. To pretend. So, assumed facts are pretend facts. To undertake, to engage, to promise, to take to or upon oneself, to assume. Also taking up, receiving, adopting, taking to oneself, or to put on deceitfully, to take appearance of, affect, or outwardly seem. To take on, become bound as another is bound, or to put oneself in place of another as to an obligation or liability. I'm not going to be a sacrificial lamb for anybody. I'm not going to take one for the team. None of that stuff. That's being persuaded by belief. So I'm going to go to knowledge. I'll be closing up with knowledge here probably for the night. I know that it's heavy stuff. Let's see where knowledge is. Okay, knowledge. To know. Do you realize, back to, what is it? I did this last Thursday, Minnesota 220. I'm going to go to knowledge, and then I'm going to explain 220 again, why it's important to know why 220 is so important. That's very circular. Thank you very much, Kurt. Knowledge. Page 784. Acquaintance with fact or truth. It has also been defined as an act or state of knowing or understanding. Actual knowledge, notice, or information. An assurance of fact or proposition founded on perception by senses or intuition. Clear perception of that which exists or the truth, fact or duty, firm belief. Isn't that funny? Firm belief. Information of fact. Means of mental impression. I'm looking for other things here. It says personal cognizance or knowledge or means of knowledge. Personal cognizance or knowledge or means of knowledge. State of being. State of being. Or having become aware of fact or truth. Let me say that one more time. State of being. or having become aware of fact or truth. So here's why Minnesota 220 is so important to do properly. I talked about the alpha and the omega. That's a timeline of your life. It's a timeline of your life. The beginning of your life is the moment of conception, when the sperm enters the ovum, and when those two, when that genetic material from mom and dad starts to blend together, it creates a unique, new, separate individual, and that is you. The moment that biological material is bound together is the beginning of your biological existence, of substance. That's the beginning. I don't know when the I am enters the body or enters that vessel. I don't know. Usually, I mean, if I had to guess, it would be the moment that the spark enters the SA node and the heart starts to beat. That would be my guess. The spirit enters the body the moment that heart starts beating. And I'm just guessing because I don't really know. So once the biological material creates the what? The land or the ground or the house for that spirit to enter, the little spirit comes in and enters the sinoatrial node of the heart and starts beating. And it beats from that moment, called the alpha, all the way to the moment called the omega, which is the end of the life. And the end of the life is when that little spark leaves the SA node and goes back into wherever it came from. And all the time in between is your timeline. It's yours. But the problem with what they've done to us is because we cannot remember, we cannot recall the moment of our arrival here. We have to trust the witnesses that signed a piece of paper that reference our arrival. In my case, my arrival to Winnebago County in the state of Illinois, or Illinois State, within a republic or a country known as the United States of America. If I do not tie myself to that record, I am not here. If I don't tie myself to that record, I'm in the present moment right now. That record indicates a beginning point. If I don't go all the way back to the beginning and pull myself out of that frozen state, that frozen first day, it says here in Minnesota Rule 220 that if I do this properly, it proves that I have attained the age of majority at a date 18 years after the date. That means time finally started ticking off. If I do not claim that event, I am frozen at that moment, that beginning, forever, as if I never moved off that space. You're frozen in time, and your assets are frozen at that same moment. The Seneca Vine says when a man proves life, he's revested with his title. Until you go back there and remember that left behind material and use this piece of paper that documents your arrival, until you do that, you are not in the United States of America, and you do not exist. Your mind, body, and spirit are separated. The church and state are separated in your existence. Humpty and Dumpty are broken. They have made it possible to bring the Bible to life. Scientifically, they brought the Bible to life. But I'm going to tell you right now, if you can hear my voice right now, You do not need salvation. If you can hear my voice right now, you do not need salvation. Salvation implies separation. And you are not separated, because if you were, you would be dead. All the stuff that I'm trying to do here in my life, and hopefully it makes sense to you over time, is I just want to be living in truth. You go back to that Matthew 9, where Christ says, they that be whole need not a physician. That's Father, Son, Holy Ghost, mind, body, spirit, all in one place at one moment in time. Make the claim, and then stand your ground, and then to let Article 38 of the Lieber Code kick in. And you'll be fully indemnified by the United States of America as one of their own, one of the Article 4 citizens that have the Constitution backing them up and the Bill of Rights protecting them. And finally, I'll say this and shut the hell up. The First Amendment. The First Amendment says Congress shall make no law respecting an establishment of religion, nor prohibiting the free exercise thereof. The union of the man and his bride, the church and the state, that union is what they're speaking of in the First Amendment. Congress shall make no law respecting an establishment of religion nor prohibiting the free exercise thereof. It's the temple of God. Unum Sanctum. The Roman Catholic Church in 1302 said the same damn thing. The spiritual man shall be judged by no man. Everybody's agreeing on this, people. Everybody. All the world power agrees with this one idea. So, when it's all said and done, we're going to have all this stuff. If you choose to do what I did, that's great. If you have a better idea, go for it. But that's not. I'm not telling people what to do. I'm just trying to point out what makes sense. It just takes a lot of work to get there, and you need to let go of all this nonsensical beliefs because they're poisoning you. By the way, I'm going to leave you with something that's kind of strange. The idea of the dead, biblically, the dead. The dead are considered the unclean. Lazarus was the unclean. He was the dead. Unclean. It's funny that the word sanitation and sanitary and sanity and the fact that it says that cleanliness is next to godliness. So sanitation, the word clean, and sanity, or sanity is the same, it's the root. So to be unclean is to be unsanitized or insane. The world of the dead is insanity. Unclean, the dead, is insane. To claim to be the dead is insanity. Again, you're right back in the courtroom claiming to be something you're not. You are convicting yourself with your beliefs. It's not possible. Eternal life is not possible. The biological body dies. And the spirit is relieved of the burden of substance. The only thing that has eternal life in this world is a corporation. Man dies. Maybe it's time to let go of all that nonsensical stuff and start living for the first time. I want nothing to do with eternal life. I want to live in the present moment and experience the world of biology with beautiful friends and family and that. I do not care about eternal life, which is a fictitious pile of hue. I think actually it is Haslam versus Lockwood. It really is the horse shit. We really are living through that horse shit, that afterbirth, that second coming. Okay, I'm pushing the podium away. Oh my God, I can't believe I got onto this garbage. So that's it for the night. I'm going to get back into Haslam tomorrow and finish that up. And then, but by the way, while I have everybody on here, I think I'm either going to tell you what I'd like you to start reading, because it's one of my favorite. It's also one of my favorite documents. Where is that? Oh, I know. It's one of my favorite documents, and it is in P Cloud. And it's really fun when you start to see it. It is, there it is. The name of the document is Possession is as the root of title. Possession as the root of title. It's one of my favorite documents out there. Take your time and read it. It's really a fun read. Hopefully you'll start to see what you need to see in there. But if you think about it, possession as the root of title. And on that note, I'm getting out of here 8 minutes early, which is good for everybody.